Good morning, I'm Gary DeWaal, and this is Bridging the Week for September 10th to 14th, and today is September 17th, 2018. A federal court in Brooklyn, New York issued a much-anticipated decision holding that digital assets issued as part of initial coin offerings could be securities under applicable law. Separately, on Friday evening, the Commodity Futures Trading Commission announced the filing and settlement of 12 separate actions naming multiple companies and persons based on allegations of acting without proper registration, as well as audit trail, record-keeping, and swaps reporting violations. Much of the southeast United States was pummeled this past weekend by the remnants of Hurricane Florence, while much of the western U.S. remains unreasonably dry and terrible fires or threats of fires persist. So I can ignore all the weather and just get my job done. Let's get started. A U.S. federal court in Brooklyn, New York declined to dismiss a criminal indictment against Maxim Zasolinsky in October 2017, charging him with securities fraud and related offenses in connection with two cryptocurrency investment schemes and their related initial coin offerings. Mr. Zasolinsky had argued that the indictment should be dismissed because his activities did not involve securities and the relevant law prohibiting fraud in connection with the offer and sale of securities was unconstitutionally vague. The court rejected Mr. Zasolinsky's arguments, saying that, at least for the basis of the defendant's motion to dismiss, the government had sufficiently alleged that the relevant digital assets were securities and that the relevant law prohibiting fraud is not unconstitutionally vague as applied in his case. This decision is a very important decision for both the Department of Justice and the Securities and Exchange Commission, as it confirms the SEC's position that crypto assets issued as part of ICOs could be securities if they satisfy the elements of an investment contract as set forth in the 1946 Supreme Court decision, SEC versus W.J. Howie. Separately, the SEC and the Financial Industry Regulatory Authority brought unrelated enforcement actions against multiple defendants for disparate violations of securities law for transactions involving digital assets. The SEC settled its two enforcement matters. The FINRA matter is still pending. This is the first action brought by FINRA in this space. In an unusual Friday evening blitz after 6 p.m. Eastern Time, the Commodity Futures Trading Commission announced the filing and settlement of 12 enforcement actions against multiple corporate and individuals for violations of applicable law and CFTC rules. Two cases that raised particular noteworthy issues involved ABN AMRO Clearing and Mobius Risk Group, a risk management firm. In the action against ABN AMRO Clearing, Chicago, the CFTC said the firm did not retain, as required, electronic audit trail information for 65 clients. This problem was discovered when the CFTC found gaps in missing transaction records in response to the firm's production to a request for documents related to one client. In response, ABN initiated an internal investigation and discovered its more widespread breakdowns. These were caused by the failure in an archiving system to copy data supplied to the firm by an external vendor that occurred from January 24, 2014 through August 28, 2015. The CFTC noted that although ABN had a record-keeping system in place, it had no system to monitor whether its archiving system was properly collecting or storing data. ABN agreed to pay a fine of $160,000 to resolve the CFTC's enforcement action. Separately, Mobius Risk Group resolved an allegation by the CFTC that from approximately October 2012 to August 2018, it acted as a commodity trading advisor in providing risk management advice to its energy clients, which included advice related to the advisability of trading in over-the-counter swaps and commodity options in oil, natural gas, and liquefied natural gas without registering in such capacity. Services Mobius provided in the normal course, all for a flat fee, included market analysis and monitoring, risk strategy management, customized risk management services, market forecasting, and trade execution as agent. Mobius clients apparently were all eligible contract participants and legally qualified under applicable law to enter into over-the-counter swaps. the firm consented to pay a fine of $75,000 to resolve the CFTC's allegations. Other cases brought and settled by the CFTC involved a Hong Kong-based entity that breached position limits in soybeans and failed to file Form 204s, as well as against a swap dealer that had encountered numerous issues related to its swaps reporting to swap data repositories since 2013. And finally, the Securities and Exchange Commission brought and settled an enforcement action against Convergix Execution Solutions, a registered broker-dealer, for submitting to it data in response to a high number of electronic blue sheet requests that was incomplete or deficient. These deficiencies, which occurred from May 2012 through February 28, 2016, included customer identifying information, including a customer name, address, or taxpayer identification. The SEC said that other missing or deficient fields related to information about the securities transaction reported, including order execution times, exchange codes, transaction type identifiers, and certain execution information that was reported on an aggregate but not on a per-trade basis. Convergix agreed to pay a fine of $2.75 million to settle the SEC's enforcement action. Relevant entities that may be required to file electronic blue sheets with regulators should periodically review submissions against source information to ensure that their systems are properly calibrated to collect and process internal data correctly. By the way, blue sheets refer to trade data submitted by certain regulated entities, including broker-dealers, to the SEC and FINRA in an automated form in response to requests by the regulatory bodies in connection with their investigations, typically of equity market activity. Well, that's it for this week's edition of Bridging the Week. As always, there's more information in each article and more articles on the article version of Bridging the Week on the website, www.bridgingtheweek.com. Check it out. I'm Gary DeWaal. Have a great week, and until the next edition of Bridging the Week, ciao.